Welcome back, everyone, to Criminal Law and to the third lecture in our Foundations of Criminal Law module. In the last recording, I introduced you to what mens rea is, how mens rea differs from the requirement of a voluntary act, and what the common law approach to the topic generally looks like. During that lecture, we also covered a few of the common law approach to mens rea's many shortcomings. In the process, I explained how in this class, we're going to primarily focus on the model penal code approach, which is the modern representative scheme for dealing with mens rea issues. Now, I know this class is filled with mens rea enthusiasts who are overjoyed to hear about this. Like, you just couldn't wait to learn more about the MPC approach. Well, in that case, I have some great news for you. Today is your special day. Because in this recording, I'm going to teach you about the most important components of the model penal code approach to mens rea. As we'll learn in this recording, the MPC approach is not only the most popular approach to dealing with mens rea policy from a legislative and judicial perspective, it's also the clearest and most precise way to get a firm grasp on a very slippery topic from an academic perspective. So there are four main learning objectives for today's lecture. First, I'm going to introduce you to the model penal code framework of element analysis, which is the process of matching mental states to the different kinds of objective elements that make up the social harm in an offense definition. Second, we're going to explore the four main mental state distinctions employed in the model penal code's element analysis framework. They are purpose, knowledge, recklessness, and negligence, or what I'll sometimes refer to as PKRN. In the process, I'm going to teach you about how to apply these mental states to three different kinds of objective elements, what are known as nature of the conduct, result, and circumstance elements. Third and finally, we're going to learn how to apply the model penal code's special interpretive rules for conducting element analysis. All told, by the end of today's recording, you should have everything you need to begin using element analysis to determine the mens rea requirements that the government has to prove beyond a reasonable doubt to secure a criminal conviction. So with that, let's dive in. In the last recording, we discussed how the common law approach to mens rea famously, or better yet notoriously, led to a bunch of problems and created a lot of confusion. Aside from confusing voluntariness with mens rea, the common law approach produced over 70 unclear terms and concepts which ambiguously describe the mental characteristics that the government has to prove beyond a reasonable doubt. In 1952, this led the US Supreme Court to famously complain in the case of Morissette v. United States about the variety, disparity, and confusion in definitions of the requisite but elusive mental element. So at the same time SCOTUS was eloquently noticing the many problems reflected in the common law approach to mens rea, the drafters of the model penal code, well, they were working hard to solve them. Initially, the members of the American Law Institute on the MPC project intended to simply codify existing law in the same way that, say, the restatement of torts and other restatements did. But after studying the chaos and confusion created by the common law approach to mens rea, the MPC drafters determined that a systematic rethinking of the criminal law was necessary. The most important and revolutionary piece of that rethinking is the MPC approach to mens rea, which is born out of two critical insights. Both of these insights are explicitly stated in the commentary accompanying the model penal code. So here's the first, quote, "Only four concepts are needed to prescribe the minimal requirements and lay the basis for distinctions that may usefully be drawn." So the MPC drafters carefully studied all the different mens rea terms that were employed by the common law, and they came to the realization that there are really only four mental state concepts that are necessary to fulfill the two primary functions of mens rea policy. So those functions are, as we previously discussed, first, to communicate the minimum mens rea requirements for an offense, and second, to make the most important gradations in punishment based on the differences in an actor's state of mind, such as we saw in the case of homicide law. Those four mental state concepts are purpose, knowledge, recklessness, and negligence. The idea that the 70-some common law mens rea concepts can be reduced to four, well, that was pretty revolutionary. And it was also practically useful, because the possibility of using clearly defined terms such as purpose, knowledge, recklessness, and negligence to conduct all forms of mens rea analysis would substantially improve and simplify mental state evaluations. I'll tell you a little bit more about that later. For now, I want to focus on the fact that having a limited set of clearly defined mental state terms to work with is only one part of conducting a clear mens rea analysis. The second part is the second major insight from the MPC drafters. Quote, "Clear analysis requires that the question of the kind of culpability required to establish the commission of an offense be faced separately with respect to each material element of the crime. This statement expresses what we're going to refer to in this class as element analysis, which is the process of breaking down the social harm of an offense into its constituent parts, known as objective elements, and then analyzing the culpable mental state requirement that's applicable to each of those objective elements. Let me illustrate with some examples. So consider an assault of a police officer statute, or what we'll refer to as APO for short, that prohibits the following, quote, knowingly causing bodily injury to a police officer. So the social harm of this APO offense is what's left after you subtract the purposely mental state from the offense definition, that is, quote, causing bodily injury to a police officer. This social harm is expressed through two objective elements. The first objective element of causing bodily injury is what the drafters of the MPC refer to as a result element. The second objective element, that the person to whom bodily injury is caused be a police officer, is what drafters of the Model Penal Code refer to as circumstance elements. So look, the MPC doesn't expressly define either of these categories or what they mean, but the difference between them often seems relatively clear. On the one hand, result elements are the aspect of an offense's social harm which requires certain consequences to flow from the wrongful conduct. So for example, assault requires proof of the result element of bodily injury, homicide requires proof of the result element of death, and an offense prohibiting the destruction of public property requires proof of the result element of destruction. By contrast, circumstance elements are the situational conditions and victim characteristics which describe the social harm in an offense definition. So for example, an assault offense might require proof that the person injured be a child or a police officer. A property crime might require proof that the property destroyed was owned by the public. And a drug crime might require proof that the substance manufactured be a controlled substance. The MPC drafters recognize, and element analysis says, that the only way to definitively assess the government's burden of proof for mens rea is to determine the mental state requirements that govern each of these objective elements. So for example, to understand the mens rea for the APO statute, it's not enough to think in terms of whether someone knowingly assaulted a police officer in a general sense. Instead, you need to carefully analyze first whether someone knew their conduct would cause the result of bodily injury, and second, whether someone knew that the person suffering the bodily injury was a police officer. The MPC drafters understood how so much of the confusion over mens rea at common law was a product of courts and legislatures failing to recognize this point. And so the MPC drafters developed a mens rea framework that would place these kinds of considerations front and center, as we'll soon learn. But before we go any further learning that framework, I want to pause and provide you with some big picture thoughts about studying the MPC approach to mens rea. The first is an important acknowledgement. Look, this material is tough, and learning the MPC framework takes time. Yes, it's true that the MPC understanding of mens rea blew away the clouds of ambiguity that hung over the topic under the common law approach. But to some extent, ignorance may have been bliss, because once you have a clear view of what mens rea is, you also come to appreciate just how complicated it can be to determine the government's burden of proof in individual cases. So please be patient with yourself. I can't tell you how many students I've had who initially struggled with the topic, only to experience major breakthroughs later on in the semester. So if the MPC approach to mens rea doesn't immediately click for you, please don't worry or give up. And know that I'm always here to support you. So I have another acknowledgement to share with you, and that's this. The MPC approach to mens rea isn't perfect, and it can be quite frustrating. There's some places where I think the MPC unnecessarily complicates things, and as we'll later discuss, I actually spent 6 years of my life working on mens rea legislation in Washington, D.C. that would substantially simplify and improve upon the MPC approach. But here's the thing, that legislation isn't currently law in D.C. or any other jurisdiction. And so while the MPC approach to mens rea isn't perfect, it's the best approach currently applied by any U.S. jurisdiction. And it's also the approach applied in most jurisdictions. For example, 29 of the 35 some states that successfully completed comprehensive code reform projects adopted some form of the MPC's general mens rea provisions. And the courts in the many jurisdictions without these general legislative provisions still frequently rely on the MPC's vision of element analysis to understand and interpret their own criminal statutes. All of this legislative and judicial influence has made the MPC approach to mens rea the representative modern culpability scheme. And so that's the culpability scheme we're going to learn in this class, warts and all. The third thought I want to share with you is a recommendation. So as you know, this is a class focused on reading statutes. And in the real world, the mens rea for most criminal statutes is derived from something like the model penal code provisions we'll cover today. So I can guarantee you that on the exam, you'll be asked to apply something approximating those provisions. The good news is that I'm going to provide you with the relevant provisions on the exam, so you don't actually need to memorize any aspect of the MPC. Your task on the exam is going to be to read, understand, and apply the MPC or similar provisions I provide you with, just like any lawyer practicing in a criminal court would be required to do. As a result, don't just passively accept the plain English explanations of the mens rea terms I provide you with. It might seem tempting to just sit back and learn about the MPC secondhand from me, but don't give in to the temptation. It's important that you continually check in with the text of the model penal code itself and follow along as we work through the material. So that way you can understand where my explanations are coming from and what the relevant statutory language actually looks like. Because reading and interpreting statutory text is a critical piece of being a criminal attorney. And who knows, one day you might be one of them. Sound good? I hope so. So with that background, let's now dig into the MPC approach to mens rea piece by piece. The first piece, and arguably the most central piece, is Model Penal Code Section 2.022, which defines the mental states of purpose, knowledge, recklessness, and negligence, or what I'll refer to as PKRN. If you can, pause this recording for a couple of minutes to read through MPC Section 2.02 yourself and reflect on this provision's meaning, structure, and format. Once you're done with the recording, hit play again. Okay, welcome back. What you just read is the Model Penal Code's culpability hierarchy of 4 mental states, each of which are specifically defined with respect to the kind of element it applies to. So we're going to work through all these specific definitions, but to get things started, I want to start with the meaning of purpose, knowledge, recklessness, and negligence as those terms specifically apply to result elements. Again, result elements, as I mentioned earlier, are the aspect of an offense's social harm that require certain consequences to flow from wrongful conduct. So for example, assault requires proof of the result element of bodily injury, homicide requires proof of the result element of death, and an offense prohibiting the destruction of public property requires proof of the result element of destruction. The Model Penal Code offers special definitions of purpose, knowledge, recklessness, and negligence when those terms apply to these kinds of result elements. Let's take these definitions one by one, beginning with purpose. So Model Penal Code Section 2.02a defines acting purposely as to a result element as follows. Quote, a person acts purposely with respect to a material element of offense when, if the element involves a result thereof, it is his conscious object to cause such a result. What does this mean? Well, basically, under the Model Penal Code, a person acts purposely as to a result element when he or she consciously desires to cause it, which is to say that the harm is the person's goal. So for example, if Darlene pulls the trigger of a loaded gun with the goal of killing Victor, who's sitting in front of the gun's barrel, well then Darlene acts purposely with respect to causing the death of Victor. So with that, here are a few things to note about the Model Penal Code definition of purpose. First, if the MPC definition of purpose sounds familiar, well, that's because it is. What the MPC defines as purpose is the first of the 2 mental states that will satisfy the common law definition of intent, which we learned about during the last recording. So the drafters of the Model Penal Code deliberately used the term purpose rather than intent to avoid any association with the confusion surrounding the common law term of intent. Nevertheless, some MPC jurisdictions have chosen to codify the MPC definition of purpose by using the label intent instead. Semantically, this is pretty confusing, but practically, it doesn't have any substantive impact on the application or interpretation of the criminal law. So for example, if you were asked to apply a mental state provision that used the label intent to describe the mental state of consciously desiring to cause harm, it would apply no differently than if you were given the MPC label of purpose. Okay, the second point I want to highlight is that purpose is a demanding requirement, which is often difficult to prove because it focuses on whether the actor had a particular desire or goal. So for example, an offense that prohibits purposely destroying property requires more than a showing that the person was merely aware that destruction would or even might result from their conduct. Instead, it has to be proven that the person's conduct was more or less motivated by their desire to destroy property. And that can be pretty difficult to prove in practice. So it's also quite rare in practice that only proof of purposely causing a result element will suffice for criminal liability. Usually, for most statutes, proof that a result element was knowingly caused will also satisfy an offense. But what does that kind of knowledge actually entail? Let's take a look at the Model Penal Code definition of acting knowingly as a result element. Quote, a person acts knowingly with respect to a material element of an offense when, if the element involves a result of his conduct, he is aware that it is practically certain that his conduct will cause such a result. What does this mean? Well, basically under the Model Penal Code, a person knowingly causes a given harm when he or she is practically certain that harm will occur. So for example, imagine that Dina speeds through a red light in a large SUV, aware that a pedestrian is in the middle of the crosswalk and right in front of Dina's speeding motor vehicle. Under these circumstances, Dina's practically certain that the pedestrian will be killed. Okay, so with that, here are a few things to note about the Model Penal Code definition of knowledge. First, and once again, if the MPC definition of knowledge sounds familiar, well, that's because it is. What the MPC defines as knowledge is the second of the two mental states that will satisfy the common law definition of intent, which we learned about during the last lecture. The drafters of the Model Penal Code deliberately use the term knowledge, again, rather than intent, to avoid any association with the confusion surrounding the common law term of intent. Second, the essence of the distinction between knowledge and purpose is the presence or absence of a positive desire to cause a result. Whereas knowledge involves the actor's awareness that something will happen, purpose means that the actor affirmatively wants it to happen. So for knowledge, whether or not a person desires harm to occur is irrelevant. All that matters is subjective awareness that harm is practically certain to result. Okay, here's the third point. Don't let yourself be misled by what a reasonable person should have known under the circumstances. That's because knowledge is a subjective mental state. And this means that at the end of the day, what matters is what the defendant was actually thinking, not what they should have been thinking if they're a reasonable person. Should someone holding a loaded gun know that pulling the trigger would expel an explosive device harming anything in front of it? Absolutely. But if the defendant honestly thought the gun was a prop, well then he can't be convicted for knowingly killing the person standing in front of him because he wasn't practically certain that pulling the trigger would cause harm to anyone. The fact that a reasonable person in the defendant's situation would have been aware, doesn't change the result. Of course, proof of what a reasonable person should have known under the circumstances can provide evidence of what the defendant did know on the assumption that most people are reasonable. However, and this is important, if the defendant wasn't practically certain about causing a result, well then that's the end of the analysis for knowledge. At that point, what a reasonable person should have known becomes immaterial. Okay, so again, a person acts knowingly with respect to a result if he or she is practically certain that their conduct will cause the result. Note here that practical certainty is a very high level of awareness, less than but close to absolute 100% certainty. Okay, but what happens in the situation of someone who causes some prohibited result but isn't that certain it will occur? Instead of being practically certain, let's say this individual is only aware of a substantial risk that the prohibited result will occur. Well, in that case, the Model Penal Code would say that they acted recklessly with respect to causing the result. So let's take a look at the Model Penal Code definition of recklessly. Quote, a person acts recklessly with respect to a material element of an offense when he consciously disregards a substantial and unjustifiable risk that the material element will result from his conduct. What does this mean? Well, basically under the MPC approach, a person recklessly causes a given harm when he or she is aware that a harm is substantially possible to occur under the circumstances. So let's recall the last hypothetical, which involved Denise, who sped through a red light in a large SUV and was practically certain that a pedestrian was in the middle of the crosswalk, might be killed. Now, let's contrast the situation with one involving recklessness. Here, Denise speeds through the red light, but the pedestrian is just walking into the crosswalk at the point she steps on the gas. So from Denise's vantage point, it seems most likely that Denise will zoom by without making any contact. At the same time, Denise is also aware that impact, resulting in death, is a substantial risk under the circumstances. So if, for example, the pedestrian's on rollerblades and is moving fast enough to be fatally hit, well then Denise can be said to have recklessly killed the pedestrian. Here are a few things to note about the Model Penal Code definition of recklessness. First, and once again, if the MPC definition of recklessness sounds familiar, that's because it is. What the MPC defines as recklessness is the third of the three mental states that will satisfy the common law definition of malice, which we learned about during the last lecture. Second, and at the risk of being repetitive, the most central distinction between knowledge and recklessness lies in the degree of risk of harm that the actor is aware of. For knowledge, it's awareness as to a practical certainty that harm will occur, whereas for recklessness, it's awareness of a substantial risk that harm will occur. This is different than the categorical distinction between MPC purpose, which involves an actor's goals and desires, and MPC knowledge, which involves the actor's perceptions and factual beliefs. MPC recklessness is like knowledge in this regard, differing from knowledge only by degree, and falling at a lower point on the spectrum of relative certainty of awareness. Third, for the MPC definition of recklessness, but not knowledge, there is an independent requirement that the risk consciously disregarded be unjustifiable. As the MPC text states, the defendant must consciously disregard a substantial and unjustifiable risk. What's going on here? So the MPC drafters recognize that risk-taking is a routine and often unavoidable aspect of life, which can be necessary to further important societal interests. Consider, for example, performing open-heart surgery, building a skyscraper, or operating an emergency response vehicle. Conducting any of these activities necessarily creates substantial risks of harm, but taking those risks can be necessary and appropriate for the overall flourishing of society. And where someone takes a justified risk, well then their conduct fails to manifest the kind of insensitivity to the interests of other people that mens rea requirements exist to punish. So then it makes sense to exclude these individuals from the reach of the criminal law. That's what the use of the term unjustifiable in the MPC definition is trying to accomplish. However, it's important to note that what the MPC has in mind is an objective analysis, not a subjective one. In other words, there's no requirement for the government to prove that a reckless actor was subjectively aware of a risk that his or her conduct was unjustifiable. All that needs to be proven is that the reckless actor was subjectively aware that the risk was substantial. And then it's up to the fact finder, that is the court or jury, to objectively assess whether the defendant's conduct was justified under the circumstances. I recognize this distinction may seem kind of complicated, but on reflection, it's pretty sensible given the difficulty of proving subjective awareness as to the unjustifiability of one's conduct. And even more important, because selfish criminals may have some pretty warped views of what type of conduct is justified. So look, the good news is that we'll spend almost an entire class working through the recklessness analysis in greater detail. For now, we're going to set the justifiability prong aside and just focus on the core of recklessness, which is being aware of a substantial risk that a given harm will occur. With that in mind, the final thing I want to note about the MPC definition of recklessness is that the risk consciously disregarded must be the risk prohibited by the statute. Recklessness is not a generally guilty state of mind, and it's not enough for the government to prove that the defendant consciously disregarded a substantial risk that something bad would happen. Instead, the government has to specifically prove that the defendant consciously disregarded a substantial risk of causing the result prohibited by the statute. To illustrate, consider the following scenario. One day, David begins hitting golf balls toward a school playground, aware that doing so might result in the destruction of nearby car windows. At the same time, David also firmly believes that no children are on the playground at the time he's hitting golf balls. As a result, David is unaware of any risk that hitting golf balls will injure a human being. As it turns out, and unfortunately, David's mistaken. There are some small children playing under a park bench, and one of them pops out just as one of David's balls begins to descend from the sky, thereby severely injuring this now no longer hidden child's arm. Based on this injury, David's prosecuted for assault under a statute that reads, quote, "No person shall recklessly cause bodily injury to another person." Can David be convicted? If you can, pause the recording to reflect. Welcome back. So the answer to the question is no. David cannot be convicted under the MPC because he lacks the kind of subjective awareness required by the statute. To secure conviction for assault, the government would have to prove that David recklessly caused bodily injury to the child, and that it cannot do because David did not consciously disregard a substantial risk that bodily injury would result from his conduct. After all, we're specifically told that David was completely unaware that there were any children on the field. True, we're also told that David consciously disregarded a substantial risk that he would destroy property. But that is materially different than the conscious disregard of a substantial risk of bodily injury required by the statute. Make sense? I hope so. Okay, so we've now learned about 3 subjective MPC mens rea terms: recklessness, knowledge, and purpose. These terms are subjective in the sense that they refer to the desires and beliefs actually possessed by an actor at the moment they engage in criminally prohibited conduct. By contrast, the 4th MPC mental state, negligence, is objective. That is, negligence is the failure to be aware of a substantial and unjustifiable risk that one's conduct will cause harm under circumstances where a reasonable person would have possessed that awareness. Let's take a look at the Model Penal Code definition of negligence. Quote, a person acts negligently with respect to a material element of an offense when he should be aware of a substantial and unjustifiable risk that the material element will result from his conduct. What does this mean? Well, basically, under the MPC, a person acts negligently as to a result when they were not but should have been aware that harm was substantially possible to be caused. In this sense, the MPC definition of negligence is identical to that of recklessness with one critical difference. There's no requirement of subjective awareness as there is for recklessness. Think about it like this. Whereas recklessness focuses on whether the actor was aware of a substantial risk, negligence asks whether the actor should have been aware of a substantial risk, even though the actor wasn't aware of it. In this sense, acting unreasonably is sufficient to support a criminal conviction for negligence, but not recklessness under the circumstances. In practice, the fact patterns that satisfy negligence are almost identical to those that satisfy recklessness, with one important exception. For negligence, the government doesn't need to prove conscious awareness of a risk. All that matters is whether a reasonable person would have been aware of the risk under the circumstances. So, for example, let's revisit our friend David from the golf ball hitting hypo I mentioned earlier. In that hypo, we saw how David could not be convicted of reckless assault because he was unaware there were any children on the playground, and so David was unaware of a substantial risk that by hitting the golf ball, he would cause bodily injury. However, on these facts, David should have been aware of a substantial risk that hitting a golf ball toward a playground would result in bodily injury. And so David could be convicted of negligently assaulting the child. Another common negligence scenario involves someone who hits someone with their vehicle while texting on their phone or messing with the radio when they should have been paying attention. Given the distraction, the person may not have been aware that they were creating a substantial risk of harm, but they should have been aware given the known risks of operating a motor vehicle. So in that case, these individuals could be held criminally liable for negligently causing a harm that fell within those risks. That is, provided the legislature chooses to actually criminalize negligent wrongdoings. Generally speaking, the minimum mens rea standard for most offenses is recklessness, and this reflects a common view that some awareness of wrongdoing is necessary for criminal conviction. As a result, the use of negligence is somewhat abnormal in the criminal law. In most jurisdictions, for example, there's no offense for just causing bodily harm negligently. Instead, the general rule is that the minimum mens rea for assault is recklessness. But there are exceptions. So, for example, it's quite common for jurisdictions to create a base homicide offense that prohibits negligently causing the death of another person. And many jurisdictions which set the minimum mens rea for assault at recklessness also contain a separate assault offense for negligently causing bodily injury with a firearm. Statutes like these reflect the view that where the harm caused is particularly egregious or the risk created by conduct are particularly extreme, negligence is an appropriate basis for criminal liability. The final thing I'd like to note about negligence is that, like recklessness, the risk disregarded must also be unjustifiable. And there's an additional requirement that's also applicable to recklessness, that the disregard of a risk be a gross deviation from a reasonable standard of care. We'll cover the meaning of these terms and phrases in a later lecture. For now, you have the information you need to perform a basic analysis of negligence. Okay, so that's an introduction to the Model Penal Code's 4 key mental state terms: purpose, knowledge, recklessness, and negligence, as they apply to result elements. But if you take a look at the MPC, you'll notice that mens rea also applies to something called circumstance elements. But what are those? Well, as I mentioned earlier in the lecture, the MPC doesn't explicitly define the categories of elements, but in practice, circumstance elements are the situational conditions and victim characteristics which describe the social harm in an offense definition. So, for example, an assault offense might require proof that the person injured be a child or police officer. A property crime might require proof that the property destroyed had been public. And a drug crime might require proof that the substance manufactured was a controlled substance. Those are circumstance elements. Culpable mental state requirements apply to circumstance elements in much the same way as they apply to result elements. The only thing, and it can be a confusing one, is that the MPC definitions of purpose, knowledge, recklessness, and negligence sometimes change depending upon the nature of the element it applies to. So for example, let's take a look at the MPC definition of purpose as it applies to circumstance elements. That definition reads as follows. Quote, a person acts purposely with respect to a material element of offense when, if the element involves the attendant circumstances, he is aware of the existence of such circumstances, or he believes or hopes that they exist. What does this mean? Well, basically, a person acts purposely as to a circumstance element under the MPC if they're aware, believes, or hope that the relevant attendant circumstance exists. So for example, a person purposely assaults a police officer if they're aware, believe, or hope that the person they're punching is a police officer. The most important thing to note about this definition of purpose is that it does not require proof that a person consciously desired an attendant circumstance to exist in the same way that it has to for a result element. So for example, to purposely kill, death must be desired, not merely foreseen. However, to purposely take property worth more than $1,000, it is enough for the thief to be aware, believe, or hope that the property is worth more than $1,000. In other words, the thief doesn't need to affirmatively desire the property to be worth more than $1,000. Practically speaking, this means that the distinction between the presence or absence of a positive desire, otherwise reflected in the model penal code definitions of purpose and knowledge as to results, is effectively ignored in the context of circumstance elements. Why is that? Well, the model penal code is not entirely clear on this point, but as best we can tell, the MPC drafters just didn't see a real difference in this context. Okay, so with that, let's now take a look at the MPC definition of knowledge as it applies to circumstance elements. Quote, a person acts knowingly with respect to a material element of an offense when, if the element involves the attendant circumstances, he is aware that such circumstances exist. What does this mean? Basically, a person acts knowingly as to a circumstance element so long as they're aware that it exists. So for example, a person knowingly assaults a police officer if they're aware that the person they're punching is a police officer. Now, wait a minute. Doesn't this sound a lot like the definition of purposely as to a circumstance element? Indeed it does. Interestingly, the MPC definition of knowingly as to a circumstance element kind of duplicates the MPC definition of purposely as to a circumstance element. In which case, there's not much of a difference between these two terms in this context. Proof of mere awareness will satisfy both of these mental states. By contrast, there is a slight distinction between the MPC definition of knowledge as to a circumstance element and the MPC definition of knowledge as to a result element. But before we go any further into this, I want to let you know that I'm not going to test you on this distinction. Having said that, you should at least understand what the distinction is and why it exists. Okay, so the difference here is that the MPC definition of knowledge as to circumstance elements requires full or complete awareness, whereas the MPC definition of knowledge as to a result element requires a still high but slightly lesser degree of awareness as to a practical certainty. In other words, to knowingly kill, the defendant does not need to be 100% certain that death will result from his actions. Rather, he only needs to be practically certain death will result. By contrast, to knowingly take property worth more than $1,000, the defendant has to be completely aware that the property is worth more than $1,000. So what do you think the reason is for this slight difference between the MPC definitions of knowledge as to a result element and knowledge as to a circumstance element? If you can, take a moment to reflect on this question and see if you can figure it out for yourself. Welcome back. So the reason for the slight difference between the MPC definition of knowledge as to a circumstance element, which again requires full or complete awareness, and the MPC definition of knowledge as to a result element, which requires a still high but ultimately lesser degree of awareness as to a practical certainty, is as follows. Result elements are caused by an act, and thus exist in the future from when an act is occurring. As a result, one can never be 100% certain something will occur. So for example, the person you're trying to assault with your fist might try to duck at the last moment, or the gun you're trying to use to kill someone might jam at the last second. By contrast, the circumstantial fact of the victim's status, that is, whether you're trying to punch a child or shoot a police officer, exists in the present moment that a criminal act is occurring. As such, this is something a criminal actor can be fully aware of. So look, I'm going to be the first to acknowledge this is complicated, And I honestly don't think there was any need for this complication to be injected into the MPC. But my opinion is besides the point. The good news is that this conceptual distinction doesn't really have much of a practical difference. And even more important for you, I won't be testing the difference on the exam. So on the exam, you're welcome to apply either the full awareness standard or awareness as to practical certainty standard for knowledge. And that's true regardless of whether it's a circumstance or result element. And that's going to be just fine. With that, I have a little bit more good news to report. Once we drop below knowledge, there are no more confusing distinctions to report regarding mens rea as a circumstance element. The MPC definitions of recklessness and negligence are identical as to both result elements and circumstance elements, which is to say, regardless of element type, recklessness means consciously disregarding a substantial risk, whereas negligence means inadvertently disregarding a substantial risk you should have been aware of. On this understanding, a person recklessly assaults a police officer if they are aware of a substantial risk that the person that they were punching was a police officer. By contrast, a person negligently assaults a police officer if they were unaware of but should have been aware of a substantial risk that the person they were punching was a police officer. Make sense? I hope so. Okay, so at this point we've discussed how PKRN applies to result elements and circumstance elements. But if you take a look at the MPC definitions of purpose and knowledge, you'll notice that there's actually a third type of element referred to, what we might refer to as nature of the conduct elements. Consider the following definitions. Quote, a person acts purposely with respect to a material element of an offense when, if the element involves the nature of his conduct, it is his conscious object to engage in conduct of that nature. Here's knowingly. Quote, a person acts knowingly with respect to a material element of an offense when, if the element involves the nature of his conduct, he is aware that his conduct is of that nature. Consistent with these definitions, a person whose conscious object is to enter public property without permission purposely trespasses, whereas a person who is aware that their conduct, for example, stepping off the sidewalk and into the front of a building, amounts to an entrance, knowingly trespasses. And that's so in just the same way that a person's conscious object is to kill, purposely kills, whereas a person who is aware that it is practically certain their conduct, for example, shooting at a bird in front of someone's face, will result in someone's death. Okay, so what's going on here? Well, the MPC drafters believe that there are actually three types of elements that can comprise a social harm and offense: result elements, circumstance elements, and nature of the conduct elements. I say nature of the conduct element, both because that's the language used in the MPC, and because it's important to distinguish this kind of element from the bare requirement of a voluntary act, which, as we already discussed, is independent from mens rea. So for example, whereas a voluntary act merely requires proof of a willed bodily movement, nature of the conduct elements apply mens rea to the most immediate characteristics of an act or omission. Or something like that, since the precise meaning of a nature of the conduct element is unclear and never really provided by the MPC. In practice, nature of the conduct elements are generally those elements that describe the act or omission necessary to satisfy an offense definition, and which don't seem like result or circumstance elements. Some examples would include statutory terms such as taking, using, driving, touching, penetrating, and entering. Consider a joyriding offense that prohibits knowingly using a motor vehicle without consent. Here, the verb using implies an act, such as stepping on the accelerator, which must be voluntarily performed by the defendant. So that's the bare conduct element. The nature of the conduct element is the fact that this act amounts to a using in the particular context in which it occurs. In other words, to knowingly use, the person must be aware that pushing their foot on the accelerator, rather than, say, opening the driver's side door, is a form of use. Here's another example. Imagine that Drake swiped Val's wallet out of her back pocket and then is charged with theft, which is defined as knowingly taking the property of another without consent. For this offense, taking would constitute a nature of the conduct element, in which case we would plug in the appropriate definition of knowingly to the statute. This would result in the government having to prove that Drake knowingly took, which is to say that he was aware his conduct amounted to a taking, in order to secure a conviction. Note again that this awareness that one's swiping movement, taking a wallet, amounts to a taking, is very different than whether one's swiping movement is voluntary, understood in terms of it being the product of conscious effort and determination. Because again, mens rea as to nature of the conduct elements is one thing, whereas the voluntary act requirement is another. Okay, so I want to pause here to acknowledge that I think the category of the nature of the conduct elements is really confusing, and I also think that confusion is unnecessary. From my perspective, I don't really see a need to add a third category of objective element to a mens rea analysis scheme. Indeed, the criminal code I spent years working on in Washington, D.C. would do away with the concept of nature of the conduct elements entirely. But that code isn't law, and the reality is that just about every jurisdiction across the nation recognizes the possibility of nature of the conduct elements. It's not uncommon, for example, to hear courts talking about, quote, conduct crimes, like theft or joyriding. As a result, you're going to have to learn how to apply mens rea to nature of the conduct elements in this class, as you would in the real world. But there's also good news. In this class, you don't have to worry about figuring out how to spot a nature of the conduct element. The reality is that courts use this concept inconsistently, and so the category basically operates in a jurisdiction-specific basis, subject to whatever courts have said the law is. As a result, in this class, I'm going to simply identify nature of the conduct elements for you whenever they arise, both generally when we're practicing, but also specifically on the exam. Practically speaking, this means that for purposes of our class, you just need to be able to identify and distinguish result elements and circumstance elements from one another. I'll specifically tell you anytime a statute has a nature of the conduct element. Sound good? I hope so. Okay, so with that, we've just about completed our discussion of PKRN, save one final point. These four mental states form a hierarchy. That is, purpose is more blameworthy than knowledge, which is more blameworthy than recklessness, which is more blameworthy than, you guessed it, negligence. This hierarchical idea is codified by Model Penal Code Section 2.025, which establishes the following. Quote, when the law providing that negligence suffices to establish an element of an offense, such element also is established if a person acts purposely, knowingly, or recklessly. When recklessness suffices to establish an element, such element also is established if a person acts purposely or knowingly. When acting knowingly suffices to establish an element, such element also is established if a person acts purposely. So this MPC language, which has been adopted by many U.S. jurisdictions, does two things. First, it clarifies the basic philosophical point I just mentioned, that PKRN form a hierarchy of culpability. Second, and more practically, this provision establishes that proof of a higher mental state will satisfy a lower one. So for example, consider an assault statute which prohibits recklessly causing bodily injury to another person. Although this provision doesn't mention purposely or knowingly causing bodily injury, MPC Section 2.025 makes explicit what should otherwise be implicit, that causing bodily injury with a mental state more culpable than recklessness will also suffice to support criminal liability. As a result, consciously desiring to harm someone, or being practically certain that harm will result, will also support a conviction for an assault statute that only explicitly mentions recklessness. One other thing I'd like to note about this MPC provision is that it provides legislative drafters with something of a shortcut. Under MPC Section 2.025, you don't need to specify every mens rea that can possibly satisfy statute, only the lowest mens rea, because under MPC Section 2.025, the higher ones will be read in. Make sense? I hope so. Okay, so the next aspect of the Model Penal Code approach to mens rea I want to discuss is the topic of strict liability. In the last lecture, we discussed how the common law strongly disfavored strict liability, but at the same time, there were public welfare offenses and morality crimes for which exceptions were made. The Model Penal Code drafters considered these rejections and generally rejected them, with the ultimate goal of abolishing strict liability in the criminal law. This policy decision is reflected in a couple of provisions. The first is Model Penal Code Section 2.021, which reads as follows. Quote, except as provided in Section 2.05, a person is not guilty of an offense unless he acted purposely, knowingly, recklessly, or negligently, as the law may require, with respect to each material element of the offense. In effect, this provision establishes that the government has to prove some PKRN mental state for every element of an offense unless Section 2.05 says otherwise. Okay, well then what does Section 2.05 have to say? Well, that section says a lot of things, but the most important thing to know for our purposes is that it establishes that strict liability is only allowable for less serious infractions called violations for which no criminal liability or punishment can be imposed. From the drafter's perspective, strict liability policies that risked punishing the morally blameless were indefensible, and the MPC drafters understood the criminal law's commitment to the guilty mind to be too fundamental to be compromised. Big picture then, the MPC drafters hope to create a new statutory world in which true strict liability crimes no longer existed. But that hope never saw the light of day. Because at the same time that policymakers were considering the MPC's recommendations, they were confronted with rising crime rates and social disorder in the 1960s, as well as political transformations of the civil rights movement. These societal changes gave birth to a tough-on-crime approach to policymaking, which tried to make it as easy as possible for prosecutors to secure criminal convictions. And at the time, adding new mens rea requirements to statutes was not seen as amenable to that tough-on-crime project. As a result, state legislatures that adopted the model penal code's recommended mental state definitions otherwise rejected the code's proposal to abolish strict liability. How did this rejection occur? Well, sometimes state legislatures would make modifications to MPC section 2.021, but even more often, they would simply draft specific offenses in a way which courts would interpret to indicate legislative intent for strict liability to apply. One indication, and the one we'll focus on this class, is the use of the phrase "in fact" before an offense element. Consider, for example, the following statute prohibiting the assault of a police officer. No person shall knowingly cause bodily injury to someone who is, in fact, a police officer. Here, the use of the phrase "in fact" clearly indicates that the legislature did not intend for a culpable mental state requirement to apply to the circumstance element of the victim's status as a police officer. Rather, this fact, that the victim of an assault was a police officer, would be subject to strict liability. In which case, a person who was completely unaware, and indeed had absolutely no reason to believe the person they were punching was a police officer, could still be held liable for the offense. Okay, so that's the MPC's recommended but frequently ignored approach to strict liability. Now I'd like to transition to some important interpretive issues that the MPC addresses. At the outset, I want to note that element analysis' main goal is to make it easy for litigants to figure out what mental state has to be proven for each and every objective element in each and every criminal offense. That requires clear mental state definitions, but it also requires more than that, because it can be very difficult to draft statutes that explicitly state which mental states, if any, apply to individual offense elements. To illustrate, I want you to imagine an offense that reads, quote, "No person shall knowingly destroy public property worth more than $1,000 without consent." At first glance, the mens rea of this statute may seem simple enough, but on reflection, difficult interpretive choices present themselves. For example, does the term knowingly apply to every single objective element in this offense definition? That is, the result element of destruction and the three circumstance elements of public property worth more than $1,000 and without consent? Because in that case, the government would not only have to prove that the accused was practically certain that his conduct would result in destruction, but also that the accused was aware that the object destroyed was public property, was worth more than $1,000, and that the person lacked consent to engage in that destruction. Alternatively, maybe the legislature simply intended for the knowledge requirement to apply to some of these objective elements, with the rest being subject to either a less demanding mens rea requirement or maybe even strict liability. These are all possibilities, but without more clarity, all we have to rely on are arguments about legislative intent. Okay, so on that note, I want to highlight that the common law presumption of mens rea we learned about in the last class typically only applies when a statute is completely silent on mens rea. And it also only presumes mens rea applies to the most morally significant aspect of an offense. Consider, for example, a statute that vaguely prohibits, quote, causing bodily injury to a police officer without any mention of mens rea. Under the common law presumption, this statute might be presumed to require mens rea as to the result element of causing bodily injury, thereby distinguishing an accidentally caused injury from a culpably caused one. But by contrast, the common law presumption would not also necessarily presume that the legislature intended for a mens rea to apply to the circumstance of the victim's status. So where, as is often the case, a statute ambiguously states a mental state at the beginning of an offense definition, the common law presumption of mens rea wouldn't provide much guidance as to how to distribute it. By contrast, the drafters of the Model Penal Code wanted to provide courts and litigants with as much guidance as possible, and they wanted to do it in an authoritative way. The MPC drafters recognize that statutory interpretation is ultimately about discerning legislative intent. And so they basically thought to themselves, well, if statutory interpretation is all about legislative intent, well then let's go ahead and minimize the need to make contestable arguments about what legislative intent is based upon using our 3 steps to success interpretive method. Instead, the MPC drafters thought, let's just codify legislative intent through statutory rules of mental state interpretation. One of those rules, what we'll call the travel forward rule, is stated in Model Penal Code section 2.024, It reads as follows, quote, when the law defining an offense prescribes a kind of culpability that is sufficient for the commission of an offense, without distinguishing among the material elements thereof, such provision shall apply to all the material elements of the offense unless a contrary purpose plainly appears. Big picture, this provision establishes that an explicitly stated mens rea term should be read to apply to all objective elements in an offense definition, unless there's a very clear indication in the statute that the legislature intended a different outcome. In practice, and for purposes of this class, we're going to understand this provision to establish a travel forward rule, in which an explicitly enumerated mens rea term applies to all objective elements that follow it. To illustrate, let's take a look at the Model Penal Code's false imprisonment statute, section 212.3, which provides in part that it is an offense to, quote, knowingly restrain another unlawfully. So in this offense, there are two objective elements, restraining someone and doing so unlawfully. To which elements does the knowledge requirement apply? The answer, which is provided in MPC section 2.024, is that the knowledge requirement travels forward and applies to both elements. As a result, the prosecution must prove that the defendant knowingly restrained the victim and that he knew the restraint was unlawful. Now let's consider a contrast case, where a single culpability term is stated in the middle of an offense definition, that is, where some objective elements precede the culpability term and then some come after. In this situation, the mens rea term would only apply forwards but not backwards. To illustrate what this means, let's consider the Model Penal Code's burglary statute, section 221.1. This provision provides in relevant part that it's an offense to, quote, enter an occupied structure with purpose to commit a crime therein. Here, the MPC drafter's placement of the term purpose after the phrase enter an occupied structure plainly demonstrates the drafter's intention to not require purpose to apply to the preceding phase, or else it would have placed the word purposely at the start of the offense. Note, though, that this does not mean that the objective elements of, quote, entering an occupied structure are exempted from mens rea analysis or subject to strict liability, given everything we've discussed about the code. Instead, it just means that we need to look toward another MPC interpretive rule, section 2.023, which states as follows, quote, when the culpability sufficient to establish a material element of an offense is not prescribed by law, such element is established if a person acts purposely, knowingly, or recklessly with respect thereto. Okay, so this is the Model Penal Code's default recklessness rule. It requires that, in situations of uncertainty, you should read in a minimum requirement of recklessness as to any objective element for which mens rea is not otherwise clear. And remember, recklessness can be established by proof of knowledge or purpose. So, as a result, when the definition of a criminal offense is silent on mens rea as to a particular element, the default presumption under the MPC is that that element is subject to recklessness. To illustrate what this means, let's return again to the MPC definition of burglary we were just considering, which makes it an offense to, quote, enter an occupied structure with purpose to commit a crime therein. Since the mens rea governing the entry to an occupied structure is unclear after we apply the travel forward rule, we read in a mens rea of recklessness under the default rule, in which case the relevant part of the statute establishes that a person may not be convicted of burglary under the code unless he recklessly entered an occupied structure with the purpose to commit a crime inside. This is, in short, how the MPC's statutory rules of mental state interpretation operate together. And it's also a lot of information, both here and throughout today's lecture. So again, I'll be the first to acknowledge that learning the MPC approach to mens rea is challenging, particularly when you're presented with this material for the first time. But I can also tell you that with practice, review, and more practice, you'll discover that the system is pretty logical, rational, and very learnable. So that's where I'm going to end today's recording. Please consider going back to re-listen to anything that still seems particularly confusing, and then when you're ready, go ahead and give the reading and practice problems a try. We're going to spend a lot of time working through them together in class. Take care and have a great day.